Imagine a shadow government lurking in the digital ether, siphoning your every call, email, and search without a whisper of accountability. That's the National Security Agency in action, folks. Today, we're dissecting how the NSA operates as a rogue entity, vacuuming up Americans' private data en masse, all while thumbing its nose at the Constitution's ironclad protections. Let's cut straight to the chase. The NSA lacks any legitimate constitutional footing for its bulk surveillance programs. The framers never envisioned an executive branch behemoth like this, empowered by Congress through vague statutes like the Patriot Act and FISA amendments, to bypass the Fourth Amendment's demand for warrants based on probable cause. That amendment explicitly shields the people from unreasonable searches and seizures, requiring judicial oversight tied to specific suspicions, not blanket dragnets that treat every citizen as a potential threat. Yet here we are, with the NSA hoarding metadata on billions of communications, claiming it's not a search because it's just data about data. This twisted logic ignores the core intent of the Fourth, to prevent general warrants that let kings, or in this case spy chiefs, rifle through lives at will. How did judges let this monstrosity stand? Through a cocktail of secrecy and deference that mocks their oath to uphold the Constitution. The FISA court, operating in the shadows without adversarial proceedings, has approved over 99% of NSA requests, rubber-stamping expansions under doctrines like the third-party rule from old cases twisted beyond recognition. Instead of striking down these programs as violations of separation of powers, where Congress improperly delegates legislative authority to unelected spies, courts have hidden behind national security excuses, allowing executive overreach to fester. This isn't constitutional law. It's judge-made jurisprudence, a house of cards built on precedents that prioritize state power over individual sovereignty. The real-world toll on the people is devastating and insidious. Innocent Americans face chilled speech, self-censorship in online activities, and eroded trust in digital life. Think journalists hesitating to contact sources, activists dodging advocacy, or ordinary folks wondering if their private thoughts are logged in some Utah data center. We've seen leaks expose abuses, like querying U.S. persons' data without warrants, leading to wrongful targeting and privacy shredding that echoes tyrannical surveillance states of the past. If this persists unchecked, we're barreling toward a future where freedom is just a relic, supplanted by algorithmic oversight. Judges bear the blame here for forsaking their gatekeeper role. They've abdicated by accepting flimsy minimization procedures as substitutes for real warrants, shielding this state from scrutiny while leaving citizens exposed. Rather than dismantling this apparatus as an affront to enumerated rights, they've enshrined deference to agencies, turning the bench into an enabler of unchecked power. This precedent worship replaces the Constitution's plain text with bureaucratic expediency, betraying the judiciary's duty to check executive excess. Wake up, America. This NSA Leviathan isn't destiny. It's a perversion we can dismantle through awareness and reform. Demand transparency, push for legislative curbs, and hold courts accountable.